Have you ever wondered what would happen if you or a loved one had a medical emergency? What would you do if you developed a serious illness or needed to care for a family member as they underwent treatment for one? What if you or your spouse had a baby? These are just a few of the situations covered by the Family and Medical Leave Act, or FMLA. Enacted in 1993, the FMLA provides certain employees with up to 12 weeks of unpaid job-protected leave per year, and it's enforced by the Department of Labor, or DOL. There are two terms that must be defined before we discuss FMLA further: covered employer and eligible employee. A covered employer is any public agency, such as local or federal government and schools. In the private sector, employers are covered by the FMLA if they employ 50 or more employees in 20 or more work weeks in the current or previous calendar year. However, whether you specifically qualify for coverage is another matter. This brings us to the second definition. An eligible employee is someone who has worked for a covered employer for at least 12 months total, has worked at least 1,250 hours over the 12 months preceding their leave, and works at a location where the employer employs at least 50 people within 75 miles of that worksite. Eligible employees may request FMLA leave for several reasons: to care for and/or bond with a child after birth or adoption, to care for a spouse, child, or parent who has a serious health condition, or to receive treatment for a serious health condition. It's important to note that the FMLA provides protection for employees to care for a spouse. In 2015, the DOL issued a final rule amending the definition of the word spouse in the FMLA. This final rule clarifies that same-sex couples in legal marriages must be afforded the same rights as opposite-sex couples. Eligible employees in same-sex marriages can take FMLA leave to care for their spouse. The FMLA allows you to take up to 12 weeks of leave per year. There are a few other things to keep in mind, though. Under the FMLA, your leave doesn't have to be taken in one big chunk. You can take leave intermittently as long as you're qualified to do so. A week here, a week there, or all 12 weeks together. However, the FMLA does not guarantee paid leave. Paid leave is not required or guaranteed under the FMLA. Additionally, employees may choose to use their accrued paid vacation or paid sick leave for some or all of the FMLA period, and employers may require employees to do so. For example, an employee who is taking 3 weeks of FMLA and has 2 weeks of accrued vacation and sick leave could use the paid leave for the first 2 weeks and take unpaid leave for the third, and their employer may require them to do so. A serious health condition is one that requires an overnight stay in a hospital, incapacitates the employee for more than 3 consecutive days and has ongoing treatment, or is a chronic condition that causes occasional periods of incapacitation and treatment. Pregnancy is also considered a serious health condition. Caring for a parent who has a serious health condition qualifies for FMLA. However, caring for parents-in-law does not qualify for FMLA. Certain situations for military families also qualify them for FMLA, which is an amendment to the FMLA. If you or a family member are an active member of the military, a reservist, or a veteran, you may qualify for military FMLA. Now, if you have a need to use FMLA and the need for leave is foreseeable, you must request that leave at least 30 days in advance. In most cases, your employer must tell you if your request is approved within 5 business days using a form called a designation notice. To apply, you must provide enough information for an employer to reasonably determine whether FMLA applies to your situation, which may include medical certification from a healthcare provider. However, if your employer explicitly requests medical records from you or the person you care for, this is a breach of privacy and it's illegal. You should never hand over medical records to an employer to justify the need for FMLA. If you do take FMLA and you're ready to return to work, your employer must restore you to your old job or to a nearly identical one with a similar work schedule, conditions, benefits, and duties. This is the job-protected portion of the FMLA. Your employer cannot demote you or significantly change your work schedule when you return from leave. I should note that if you have a medical condition, you could be required to get a fitness for duty certification from a healthcare professional before being allowed to return to work. If you've ever worried about what would happen if you needed to take extended time off from work because of a medical condition, rest assured. For many, many employees in the US, the FMLA is a safety net that provides up to 12 weeks of job-protected leave per year. If you're unsure whether the FMLA applies to you, or if you have any other questions, reach out to your supervisor or Human Resources Department. You can also visit the Department of Labor's website at dol.gov or search your state's DOL website for more information.